Hi, my name is Nicholas Bartzen. Thank you to CAI for having me for this Ed Talk. I am a partner and founder of Altus Legal, a community association law firm based in Chicago and Oak Park. We exclusively represent community associations in Illinois. I've been in this business for 16 years, practicing community association law for the past 6. Today's Ed Talk is a question we're going to tackle, which addresses windows and doors in community associations. And the question is, should a board have a specific window and door requirement and policy in place? And the answer is a resounding yes. Now, one tidbit here is the association probably already does have some kind of policy in place. You just might not know it. It could be found in the declaration and bylaws. Declaration and bylaws for any community association most likely addresses the issue of perimeter windows and doors, which are exclusively used by one unit owner or parcel owner to the exclusion of all others. Also, if you're a condo association in Illinois, there is some policy already in place in the Illinois Condominium Property Act, which designates perimeter window and doors exclusively used by one unit as limited common elements, meaning they are owned by the association, but they are exclusively used for the benefit by one individual unit owner. Now let's unpack the fact that I just said you already have this policy in place in your declaration and bylaws. So the question may be, well, Nick, why do we need more of a policy? Are you just trying to over-lawyer this thing? The answer is maybe a little, but no, actually I'm not, because a declaration and bylaw document is generally written in verbose legal jargon, which can contradict itself. It may have one specific section in Windows in one portion, and then 45 pages later, an entirely different section with some kind of language such as notwithstanding the aforesaid, blah, 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 blah. All language intended to make attorneys feel smarter than they are in some cases. So this gets down to the nub of it. The board and the unit owners do not want to have to continually reference the declaration and bylaws, either themselves or with the assistance of an attorney, because that adds to your legal bottom line and just doesn't make sense. A one and done policy established in the association's rules and regulations, carefully drafted by either the association council or in conjunction with the association council, and then adopted as part of the rules, will give the board and management company an easy 1 to 2 page sheet that it can give out to current and prospective unit owners, addressing all of the questions they may have with windows and doors, insofar as when can we decorate them and how can we decorate them around the holidays? What paint color can the doors be? Who's responsible for cleaning the windows? What happens if a window breaks? Who's responsible for replacing the glass or the locks and the other hardware and mechanisms on the windows? All of that can be addressed in the policy. Now, why you want this policy is because, as I said, in general, windows, especially in condominium associations, are limited common elements. They're often part of the facade or some other portion of the structure of the building. And thus it makes it very important that you don't have unit owners willy-nilly replacing these windows with some kind of material that might be aesthetically ununiform with the rest of the building, or perhaps even structurally unsound. So these policies can ensure that, notwithstanding the fact unit owners may be responsible for replacing these windows themselves, the board still exercises some control, and that's control that the board doesn't want to let go of. Otherwise, it could impede the ability of the association to maintain its visual aesthetic, or even worse, compromise the structural integrity of the entire building because some unit owner decides that his or her brother-in-law is an expert at windows and they go get the cheapest windows out there, pop them in the exterior, and all of a sudden the window lintels are damaged, there's water infiltration, and a host of problems with which the board and management then have to deal with. So, how do you draft these policies? First stop is the declaration and bylaws. You see what the responsibilities are for these particular windows. It's going to be somewhere within the documents. Now, in a condominium association, the default position is generally a perimeter window, being a limited common element, is going to be the association's responsibility to maintain, repair, and replace. However, the declaration might carve out other responsibilities and shift those back to the unit owners. You're going to want to catch that language within the declaration and bylaws and write it in more clear layperson language within your window and door policy. So it's easier for the board and subsequently the unit owners to understand what he or she is responsible for. With the homeowners association, all of the information is definitely going to be within the declaration and bylaws. The Common Interest Community Association Act, which binds most HOAs and townhomes in Illinois, doesn't say much insofar as windows and doors. So the declaration and bylaws and a review of those is going to be paramount to understanding who does what with regard to the doors and windows. Let's talk very briefly about decorations, because this is a hot button issue. Is somebody allowed to hang a little flag or a political sign or a for sale by owner sign in their windows? Is a person allowed to, within the common corridor, their perimeter door to a condo unit, able to put little holiday lights around the door and leave them up for 6 months? All of those are issues that the board can put into the window and door policy to ensure that decorating, if permitted, is controlled carefully by the board such that it doesn't become a problem and the aesthetic concerns are not raised. But again, not to over-lawyer this, but a one and done policy having an association attorney look over these policies makes good sense, because you don't want to disparately treat some individuals, saying you can have Christmas lights, but all other holidays cannot have lights put up. That could run the association into some trouble. So too with certain signs and flags hung in the window. There's state law with regard to what you can hang in a window insofar as the American flag or certain flags denoting military service. However, political signs, the board can absolutely restrict those from being hung up, but you must do so in a uniform fashion. You can't say certain political signs are okay while others are not, because then again, the board runs the risk of treating individual occupants and unit owners disparately, and thus a discrimination complaint could be filed by the association. And that is, of course, best avoided. So my last thought on this, before we get into the recap of what should go in the policy, is what happens if the association checks? The board looks at the declaration and realizes it's been doing things all wrong all along. That makes sense. That can happen. It might have been historical precedent for the association to push all the responsibilities back to the unit owners. But upon careful review of the declaration and bylaws, the board notices that the board initially should have been responsible for paying all that maintenance, all those maintenance costs as a common expense from the get-go. That is something you're going to want to discuss with your association attorney. Bird's eye view here is a current board's only duty is to right the ship once you notice it is heading in the wrong direction. Going back to credit individual unit owners who may have overpaid or take money back from them for money paid for their windows, which was inappropriately paid by the association. It's very fact specific and nuanced, and you're going to want to talk to your association attorney on that. So as far as a recap, a window and door policy should be a one and done thing, done in conjunction with the hired professionals, management, and the association council, done in conjunction with the board of directors. It should include everything from window cleaning, both the interior and exterior of the windows, paint colors for the perimeter doors, how to assign maintenance responsibilities and replacement responsibilities for the windows, as well as the window locks and hardware, which might be designated as a different maintenance responsibility under the declaration. And finally, don't forget about decorating, because any good window policy and door policy should have some language with regard to that as well. Finally, my very last thought on this is everything to some extent might go out the window, no pun intended, if there is damage caused by a unit owner or occupant. If the association is responsible for replacing damaged windows, that may well be true. But if I, as a unit owner, accidentally break that window, or my contractor or employee or a very large dog smashes that window, everything need change. And the association can still perform the work, but may have the right to charge back those costs onto me as the unit owner responsible for the damage. So thank you everybody for watching. CAI asked me if you would like to comment on this particular Ed Talk. Please feel free to do so below. And if you'd like to see a longer education session on this particular topic, feel free to put that in the comments as well. Thanks very much for having me, and thank you on behalf of CAI.